Mr. Lordship,
Yes.
I would like to mention hearing item number 18.
Yes.
I pray that this matter may be listed after 2 weeks.
18.
18. Hearing
You are
item.
for?
I'm for the petitioner,
On request made by MS
Tushi Jamir.
Tushi
Jamir,
Chamir Learned Council for the petition. List after
2 weeks.
2 weeks.
Obliged, Lordship. Okay, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 5 on behalf of Livika. Pleadings are complete here, so let the matter be listed for hearing after 3 weeks.
Item 5.
Yes, Your Lordship, item 5.
Yes.
Lordship, I'm appearing on behalf of my senior Jamir.
Pleadings are complete.
Yes.
It is submitted by the parties that pleadings are complete. Issue rule. As all parties are represented, no formal steps are required. List the matter for hearing in usual course.
Your Lordship, I beg to mention item number 8 and 9. Here, state is here to file affidavit, so kindly grant me 3 weeks time.
You on time?
Yes, Your Lordship.
Objection.
Okay, heard Subhamati Learned Council for the petitioner. On request made by MSAI, Learned Government.
Yes, Your Lordship.
How much time?
3 weeks, Your Lordship.
3 weeks time is allowed to file counter affidavit.
Lordship, I'm appearing on behalf of respondent number 6 in WBC 222, Lordship. In item number 9, Lordship.
MS
221.
Apila Sanctum Learned Council appears for the respond number
6, Lordship.
6 in WBC 221 of 2022. List up to 3 weeks.
Your Lordship, item number 15 also, state is here to file affidavit. So kindly grant me 3 weeks.
Objection.
At Subhamati Learned Council for petitioner on request made by MSAI, Learned Government Advocate. 3 weeks further time is allowed to file counter. List after 3 weeks.
Your Lordship, item number 25 from the hearing list.
Mm.
On behalf of Livika, kindly let the matter come up after 2 weeks, Your Lordship.
This Lordship, I have no objection. However, Lordship, I've been informed this morning by Ms. Devika that she is willing leave for a few months. And the file is handing over to one of her colleagues. Lordship,
If she's
later-
taking leave for a few months, then you make alternative arrangements.
Yes, Your Lordship, we
Lordship,
will do that.
after 2 weeks, a date may be fixed, Lordship.
Okay. But what is Jamil, learned counsel for petitioner on request made on behalf of MS?
Livika,
Livika, learned government advocate. List the matter after 2 weeks.
Your Lordship, item number 13 on behalf of Inaholi. Kindly let the matter come up after 3 weeks. She's yet to file counter.
No objection, Lordship.
On request made on behalf of MS Inauli,
Yes, Your Lordship,
learned
Inaholi.
government advocate. How much time?
3 weeks, Your Lordship.
3 weeks. Further time is allowed to file counter affidavit. List after 3 weeks.
Much obliged, Your Lordship.
That was item
13.
Yes, Lordship.
Mm.
Lordship, I beg to mention item number 21, Lordship,
21.
part 2 hearing.
Yes.
Lordship, in similar matter, Lordship, the Advocate General has been directed to seek instruction in regarding to regularization of work charge.
Mm.
So if this matter can be listed after 3 weeks, Lordship, I've been informed by the
Okay.
additional AG.
On request made by Mozilla and the council for petition. How much time?
3 weeks, Lordship.
List the matter after 3 weeks.
Lordship. Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 10, Lordship.
Mm.
For respondent number 5, Lordship.
Mm.
I may be allowed 2 weeks' time to file my affidavit in opposition. I have received instruction, Lordship.
Okay. Government?
No, Lordship, it's a private respondent. We have already filed the affidavit.
Okay. Third MS, your good name?
Ayala Engine.
Aya,
Ayala Engine.
your name is here?
No, Lordship, I'm appearing on behalf of Tongbok Pongana.
Okay, heard MS Aya Longchim, learned counsel. Appearing on behalf of Mr. Tongpok Pongonan, learned counsel for petition. On request made by Ms. Apila Santam, learned counsel for the respond number 5. How much time?
2 weeks, Lordship.
2 weeks time is allowed to file contract. List after 2 weeks.
Obliged, Lordship.
There is an interim.
Interim order possibly to continue.
Yes, Lordship.
Yeah.
Lordship, I beg to mention item number 6. I'm making mention of the behalf of Mr. Lima Tushi, counsel for the petitioner. Lordship, he is yet to file his reply. So Lordship, can you grant 2 weeks time, Lordship?
On request made on behalf of Lima Tushil under counsel for petitioner, list the matter after 2 weeks.
Lordship, as an interim, can you let him
Interim
continue?
order passed earlier to continue till the next sitting.
Are you right?
May I please, my lord?
Yes.
Lordship, I beg to mention hearing item number 21 on behalf of
It's already adjourned.
Lordship. I'm deeply appreciative.
May I please, Lordship. My lord, I beg to mention item number 24 in hearing. This.
Yes.
My lord, I pray that may this matter be come up after 3 weeks. Ma'am.
You have 40?
For the respondent number 5.
Who appears for petitioner?
Lordship, I'm appearing for petitioner on behalf of my senior.
Okay. On request made by Mr.
B. Sotomani,
B. Soto, learned counsel for the respond number
5, ma'am.
5. List the matter after
3 weeks, ma'am.
3 weeks.
Lordship, interim order may be allowed to continue.
Interim order passed earlier to continue till the next sitting.
Much obliged.
May I please, my lord? Lordship, I beg to mention item number 17.
Yes.
Lordship, I have taken the consent from the other side, your lordship. If this matter can be listed after 3 weeks, your lordship. The state is here to file its contract affidavit, my lord.
No objection, Lordship.
Okay. Heard, Mr. Okay, can cancel it. On request made by Mr.
Inangami, my lord.
How much time?
3 weeks time, my lord.
3 weeks time is allowed to file contract. List of 3 weeks. This goes on. How is this marked like this?
I'm obliged, my lord.
May it please your lordship, I beg to mention item number 11.
Yes.
I beg to mention item number 11. In the last occasion, we have sought time to file our affidavit. However, the deponent is the resident of Mopok Chung, so we are yet to take his signature. So your lordship may kindly grant a week time.
You
to
are appearing
complete
for
Respondent 5.
respond number 5. Who
Yes,
appears
Your
for
Lordship.
petitioner? You are appearing for petitioner? Your good name?
Mathoi,
Hmm?
Mathoi,
Come a little louder.
Mathoi.
Mat-
I'm appearing on behalf of Tongpo Pungana,
Athai.
Mathoi.
Mathoi.
My name is not reflected in the court list.
Okay, write your name and give it. Third MS so and so, learned counsel for petition. On request made by MS
Tejavitsu.
Teja Vitsu, learned counsel appearing for the respond number 5. How much time?
1 week time.
1 week time is allowed to file contract. List of the week. After 1 week.
Much obliged, Your Honor.
Yes, Your Lordship, I beg to mention for item number 12. On behalf of Sashi Solo, Your Lordship, we have received affidavit in opposition filed by respondent 1, 2, and 3. Kindly give us 3 weeks time to file a reply.
3 weeks time is allowed to the learned counsel for the petitioner to file reply to the counter filed by the respondents 1, 2, and 3.
Yes, Lordship.
List up to 3 weeks.
For motion, item numbers 1 and 2.
Yes, Lordship. Lordship, this IA is filed for impleadment of 7 individuals as respondent, Lordship.
How many IAs?
2 IA, Lordship. Your Lordship, the brief fact of the case is that in the year 2010, the case was filed by 7 individuals.
Where's the proposed respondents? List of proposed respondents.
Lordship. I'm for the respondent number 5.
You have any objections?
No, Your Lordship. No objection.
Heard Mr.
Laknai Pom, Lordship.
L. Pom, learned counsel for petitioner. Also heard Mr. V. Zimomi, learned government for the opposite parties. 1, 2, 4. And Mr.
Ching Yang Pom, appearing on behalf of my senior Yang Awadi.
C. Pom, learned counsel for the respond number 5. By this application, the applicants are praying for impleadment of, then you quote A to A, page 4. 4 and 5. Huh? As party respondents number 7 to 13
7 to 13, Lordship.
in a writ petition number 98 of 2021. Correct?
Lordship.
Stop. Learned counsel for the opposite parties have no objection. Stop. This court has also produced the portion in the present application and is satisfied. Accordingly, prayer for impleadment is allowed. IS disposed. In the main writ petition, that is WBC 98, in view of the order passed today, in IO number so and so. Let again you quote, be impleaded as party respondents number
7 to 13, Lordship.
7 to 13 in the present writ petition. Notice has to go.
Lordship.
Issue notice to the newly impleaded respondents 7 to 13. Stop petitioner to take steps for service of notice on the respondents 7 to 13 by registered post AD within a week from today. Stop. Para. The petitioner is also directed to file an amended post title within a period of 1 week from today. Stop. This is the matter of 4 weeks. And the other one, item 2, you also same impleadment.
Lordship, Lordship.
Give me the file. is the one. Item 2. Heard same parties, huh? By this application, it's the same order. But it will be as respondents 13 to 18. You quote 8 to 8, page 5. Okay. Same order. And in the writ petition, same order.
For motion, item number 26 from the supplementary post list.
Yes, Lordship.
Yes.
Lordship, here the petitioner is aggrieved by the appointment of the respondent 4.
Hmm.
Lordship, here,
Where is the appointment order?
Lordship, the appointment order is at page 39, Lordship.
Hmm.
Approval is at page 38.
Hmm.
Lordship, here the vacancy arose at the Government High School, Wollongray,
Hmm.
due to the retirement of one Sri Tungkyumong Sangtam
Hmm.
on 31/8/2019. Against this vacant post, the petitioner has applied for the said post, Chokidar, and so also the respondent number 4
Hmm.
has applied on the basis of landowner. But Lordship, Lordship may come to the report where Lordship first come to the notification of the government, that is at page 31. Page 31, Lordship. Annexure 9. Lordship, relevant portion is at 3B, Lordship.
Hmm.
Lordship might be allowed to read. If there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of District concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statement from the witnesses, that is government officials of the concerned department and the district administration and village functionaries present at the time of such oral agreement should be taken by the Deputy Commissioner. The recommendation of the Deputy Commissioner should be referred with relevant documents to the Department of Land Revenue for advice in such cases by the department concerned. Lordship, here, after that, Lordship, the government has sought for verification on the land ownership, and letter dated 12/1/2023, Lordship, that is at page 33. Relevant portion is at page 34, Lordship. Lordship, I may be allowed to read the page 33 also, Lordship. With reference to letter dated so and so, Kohima dated 16 November 2020, I'm to forward here with a copy of the meeting minutes, brief report on matters pertaining to appointment of Chokidar at Wollongray JHC, which itself is explanatory. The relevant portion is page 34, Lordship. Lordship, I may be allowed to read. Brief report on matters pertaining to appointment of Chokidar at Wollongray JHC. As directed by the authority, the undersigned convened a meeting on 12 December 2022 at 1 p.m. the office chamber of the undersigned. Meeting attendance annexed, appended. The following facts was established during the course of the meeting. Lordship, relevant paragraph is paragraph 3, serial number 3. The application of Sri Maching Sangtam, that is a petitioner respondent, for the post of Chokidar at GHS Wollongray was applied against the retirement of so-and-so, claiming of land ownership of the staff quarter located at the old school building, which is still in use by the department. However, no written agreement or terms and conditions with government could be produced. Lordship. The respondent 2, respondent 4, Lordship, his appointment, he's applied on the basis of land ownership, but he could not produce any land documents. But even otherwise also, he was approved and he was
What
appointed.
about your case?
Lordship, I am a local of the area, Lordship, a candidate.
You also claiming on
No, Lordship, I'm not claiming on ownership, not land ownership.
on what basis are you claiming?
Lordship, I'm claiming that since there's a vacant post, I've applied. And the government has sought for verification on the land ownership. And letter dated 12/1/2022 at 1 p.m. the office chamber of the undersigned. Meeting attendance annexed, appended. The following facts was established during the course of the meeting. Lordship, relevant paragraph is in the said
So
post.
you want this court to give you a vector appointment, is it?
No, Your Lordship. I'm saying that Lordship, as per Article 14 and 16, Lordship. of the
What
Constitution.
Article 14 and 16? What is the violation of Article 14 and 16?
Lordship, since the respondent's appointment was made, Lordship may come to the
See,
approval.
one appointment is there on the basis of land ownership. Correct?
Lordship,
Respondent 4 is on the basis of land ownership.
he has applied, but he could not produce any documents on that, Lordship, stating that he is the landowner of the, he is the donor of the landowner where the GHC stands, Lordship. But as per the approval order, administrative
What is the
approval,
approval order?
that is at page 38, Lordship. Page 38,
Yes.
Annexure 12. Lordship may come to serial number 3. The appointment is made on the basis of land ownership certified by the Pulungre Village Council. There is one so. But Lordship, the respondent, number 4, could not produce any documents, Lordship. As per the notification of 5th March 2018, the DC should verify who is the landowner.
Are you a landowner?
No, Lordship, I'm not landowner.
Where is your locus? To
I'm saying-
challenge the appointment of.
I'm
the-
saying that, Lordship, I being a local as a candidate,
How can you just get an appointment like that? If there's no land ownership, then there has to be a public.
public Lordship, I'm saying that,
But then here's the policy of the government where the provision for appointment on land ownership, correct?
Lordship, I'm saying that, Lordship, the post held by the, now appointed by the respondent number 4 should be advertised, Lordship.
But what
I've made
about,
statement in my-
what about this land ownership?
Lordship, he is also not landowner, Lordship.
He's not a land
No,
owner.
no, he's not landowner. The report of the report is clear, Lordship.
What do you say?
The report is clear, Lordship, at page 34. Lordship, page 34, serial number 6. 5 and 6, Lordship. I mean, allowed to read, Lordship.
Where's that
Since-
policy? Where's that policy?
Policy is at page 31, Lordship.
31.
So verification was carried out.
Yes,
Good, notice scholarship.
okay, heard. Mr.
Fosiko, Lordship.
Fosiko, learn the counsel for the petition, issue notice. MS
Yes, Chang Lordship.
S. Chang, learn government advocate, enters appearance and accepts notice on behalf of respondents 1, 2, 3, 1, 2, and 3. Stop. Extra copies of the writ petition before Mr. MC. Petitioner to take steps for service of notice on respond number 4 by registered post-date within 1 week. List the matter after 4 weeks.
Lordship, let the appointment of the respondent before be outcome of the writ petition, Lordship.
Appointment of respond number 4 shall be subject to the outcome of the suit.
I'll oblige, Lord.
For admission, item number 3.
Item 3 is motion.
For motion, item number 3.
Yes.
This, my lord. My lord, the petitioner is before this honorable court seeking for direction for
Regularization,
regularization. Yes, lord.
2015 OM,
No, no, lordship, 2004.
2004.
Yes, 22nd September 2004, office memorandum, lordship.
Yes, I mean,
Your Lordship, this is with regard to posthumous regularization and it is clearly covered by Nishivi's case.
by then, your husband died in 2011, is it?
Yes, 22nd of August 2011, lordship. And then lordship, if I may take my lord to,
Why you're coming so late?
no, lordship, the case of the petition was in active consideration. And the state government has on 2 separate occasions have approved the regularization and directed the state to identify any group C or group D to facilitate the regularization for only for pensionary benefits. If I may take you to the latest approval, Lordship. Page 29, Lordship, Mr. J.
Yes.
I may be allowed to read, my lord. Inviting a reference to your letter number such and such dated 23rd August 2022 on the subject cited above, I am directed to reiterate the observation of BNR department and request to you to identify any vacant posts group C and D against which the posthumous regularization of late Dushman work charge handyman can be facilitated.
That was in 2022.
Yes, Lordship.
Then what happened?
Lordship, and we were waiting for the positive outcome, but then no action was taken. That's why we have submitted a representation dated 2/4/2024. It is at page 30, Lordship. And this representation has not yet been disposed, Lordship.
Yes, I know. You want to file affidavit?
Yes, your lordship, then
Or you are,
let notice go, your lordship.
you want notice to go?
Yes, your lordship.
But Mr. Tushi,
Olungkumar,
all
Lordship.
along the mail and counsel for the petition. Issue notice. MSAI need and the government advocate in this appearance and accepts notice on behalf of all the respondents. Notice on respondents are complete, however, extra copies so and so so and so. Respondents are allowed by contract list of the 4 weeks.
Obliged, Lordship. For motion, item number 4.
Yes, Your Lordship. Here the petitioners are seeking for service regularization, Lordship. As per the OM 2015, Your Lordship, now they have already retired, Your Lordship.
They've retired.
Yes, Lordship.
When?
In the year between 2020 to 2024, Your Lordship.
2020 to
To-
2020.
Yes, Lordship.
Why so late? Why are you coming so late?
Your Lordship, prior to retirement, Your Lordship, they were covered by the OM 2015, so they were thinking that they will be regularized as per the OM, Your Lordship. That was the reason. And then, Your Lordship, if might be allowed, Your Lordship, several other rate petitioners in another rate petition, Your Lordship, those who were appointed along with the petitioner in the same year, and then retired in the same year, they have approached this court, and then this court is disposed of the secret petition which have been closed in the petition of Your Lordship.
That I've seen.
Yes, Lordship.
Yes, notice.
My lord.
Heard, Mr. Subumati, let the council issue notice. Mr. E.T. Papom, learned council, learned government advocate, adjusts appearance and accepts notice on behalf of
All the
all the respondents. Notice on respondents are complete. However, extra copies. Respondents are allowed to complete the list of the 4 weeks.
Much obliged.
For admission, item number 7.
May I please, Your Lordship? My lord, in the last occasion, the state was directed to give the status report of the petitioner case. And my lord, I'm informed that it is still under consideration. So my lord, 3 weeks of time may be granted, my lord.
Still under consideration?
Yes, my lord.
Why? When was the last order passed? May, June, May. Okay, let him give some time.
Your Lordship. And the
But
next,
Mr. Tombo Pongal and council for the petition. On request made by Mr. E.T. Papum, learned council for the petition. Learned council for, learned government. List the matter after
3 weeks, my lord.
3 weeks to enable him to obtain appropriate instructions with regard to the to enable him to produce to apprise this court with regard to the in respect of the status report. Your Lordship, list of the 2 weeks.
Much obliged.
For admission, item number 14.
Yes, State, no counter.
Your Lordship, the
We have
five.
already filed, Lordship. We have already filed,
I've
Lordship.
not seen your counter. Okay, engineer in chief. You want to file reply or no? No,
Your Lordship, I won't be filing, Your Lordship. I won't be filing it.
you won't be filing.
Your Lordship, if the matter can be disposed of, Your Lordship, why? Because in the affidavit, they have clearly stated that I am eligible for regularization.
Where is that?
In para for Your Lordship of the affidavit in opposition.
Yes. So what direction do you want?
Lordship, if direction may be given to the respondents in order to consider as per the OM, Your Lordship, by granting a time period, Your Lordship, for the process of
How
regularization.
long do you require?
Lordship, if sufficient time may be granted, Lordship.
Sufficient time is how much?
7 months, Lordship.
Huh?
6 months, Lordship.
6 months is too long. Heard Subhamati and the council for the case. Also heard MS Cham,
Lordship.
Learned Government Advocate, appearing on behalf of all the respondents.
All the respondents.
All the respondents. Stop. Para. Where's your appointment order? Petitioner number 1.
Page 12, Your Lordship.
The petitioner number 1
Type copy page 13.
was appointed as work charge skilled labor, correct?
Yes, Lordship.
On a fixed pay of rupees 450 per month by an office order dated 7 January 1992, issued by the Executive Engineer PWD, comma, Prengsang within bracket C division. Drafter, petitioner's name is, one's name is
Srimati Arinla.
Arinla.
Your Lordship, my paragraph 2 of my petition, Lordship, I've stated
Okay.
the details.
Drafter. The petitioner number 1 was promoted to
Workshops Chukali.
work charge Jukali in the scale pay of rupees 800-1475 per month. Stop. Para. The petitioner number 2, he was appointed directly on pay scale, isn't it? Petition number 2,
Yes, Lordship, on scale, Your Lordship.
was appointed. No, 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 no. This is only promotion order. Where's your initial appointment order? You don't have the initial appointment order.
Yes, Lordship.
By then the petitioner number 2 was promoted as work charge carpenter, helper in the scale pay of rupees 375-500 per month by an office order dated 28 April 1993, issued by the executive engineer within bracket PWD within bracket H store division, Dimapur. Stop. The petitioner number 3, new para, was appointed as
Work charge tracer
work charge tracer
and
on
scale.
an ad hoc basis in the scale pay of rupees 425-750 under the Mokchung Building -1 subdivision by an office order dated 10th November 1987, issued by the executive engineer within bracket PWT, Mokchung Division. Stop. You have already supernated.
Petitioner number 3, Your Lordship. Retirement order is batch 24. 35 years in service.
Draft draft by release order dated 14th 11th
11th November
11th
2022.
November 2022. The petition number 3, on completion of 35 years of service on 10/11/2022, was released from service. The said release order was issued by the subdivisional officer -1, PWT within bracket RMB, Mokchung Division Number. Stop. Para. The petitioners in the present writ petition are praying for regularization of the service in terms of the office memorandum dated 17th March 2015, issued by the Department of Personnel and Administrative Reforms, within bracket Administrative Reforms Branch, Government of Nagaland, which provides for a scheme for regularization and observation of work charge and casual employees and revision of pay oblique wages. Stop. Para. The respondent number 4 has filed an affidavit in opposition, and para 4 of the said affidavit in opposition, which is under quote, page 2, A to A. Stop. Para MS Chang, the Council for the Elderly Government Advocate, submits that as the case of the petitioners are under consideration, the no, don't say like that, cancel that, right? Mr. Subumati, the counsel for the petitioner, submits that as the case of the petitioners are under consideration in terms of para 4 of the affidavit in opposition, a direction will be issued to the concerned authorities to expedite the matter and regularize the service of the petitioners within a specific period of time. MS S. Chang, the government advocate, has no objections. However, she prays for sufficient time in order to be given to the respondents, to the concerned authorities, for regularization of the services of petitions. Start. After hearing the learned counsel for the petitions, and after hearing the learned counsel for the petitions, as well as taking into consideration Paragraph 4 of the affidavit in opposition filed by the respondent number 4. This petition is disposed of. Directing the, who's the respondents?
Your Lordship, respondent 3 and 4.
Directing the respondent number 3 and 4 to complete the process for regularization of the services of the petitioners in terms of the office memorandum dated, where is that memo?
17/3/15, Your Lordship.
17 March 2015, as expeditiously as possible, but not later than 4 months from the date of receipt of a copy of the order with the opposite observations and amendments.
Obliged, Lordship.
For admission, item number 16.
Next, Lordship. Lordship, let it come up after other matters, Lordship. My senior is on like in the court number 2. Right.
Later. For hearing, item number 19. May I please, Your Lordship? Lordship, here the petitioner is the husband of the deceased work charge employee, Your Lordship. Here he's praying for posthumous regularization of his wife, work charge employee for
Petitioner is the husband
Lordship.
of the deceased
Deceased is the wife,
wife.
Lordship. Praying for posthumous regularization for pensioner benefit.
When did your wife die?
Lordship, 2016, Your Lordship.
2016.
Lordship. Lordship, after serving 19 years, Your Lordship.
Then what happened?
Lordship, after that, Your Lordship, the petitioner here served a representation, Your Lordship.
When?
Page number 28, Your Lordship. 27/7/2018, Your Lordship.
Page number?
28, Your Lordship.
When was this representation made?
Lordship, 17/7/2018, Your Lordship. Top left, Your Lordship. Bottom, Your Lordship.
17/7.
Lordship, 2018, Your Lordship.
Then?
Lordship, however, the representation was kept in abeyance, Your Lordship, was not considered, Your Lordship. As such, Your Lordship, the instant petition had been filed, Your Lordship. Praying for posthumous regularization of the petitioner's wife service, Your Lordship, for pensioner benefits itself, Your Lordship.
Under which policy?
Lordship, as per the CCS pension rule, Your Lordship.
CCS pension?
Lordship.
How?
If Your Lordship would come to the page number 28, Your Lordship, the representation, Your Lordship. Para 5, Your Lordship. If I may allow to read it, Your Lordship. The CCS pension rule,
Yes.
rules 1972, Your Lordship, and all its modification is applicable to the state of Nagaland, wherein Rule 2 under Government of India's Order Para 2, Subpara 3, Para 2(3), and so on, so Your Lordship, provides as follows. That benefits in the event of death in harness of temporary quasi-permanent government servant, the family shall be eligible to the family pension debt gratuity on the basis of small same scale of admissible to the families of permanent government employees. Lordship, here the
You were serving as what?
workers employee, Your Lordship.
Work charge.
Lordship. Lordship, what the government have made advertisements in the affidavit is that since the petitioner was a temporary employee, Your Lordship, he was not applicable for the to be replaced, Your Lordship.
What is the meaning of temporary in the under the symbols under the CCS rules?
Temporary.
Check up the CCS rules. Give me the CCS rules. CCS pension rules. Your wife, your husband.
Wife, your lordship.
Wife died in 2016.
Your lordship,
When did you file this writ petition?
2019, your lordship. Lordship, 1 year after the representation was filed, your lordship.
CCS pension rules. CCS pension rules. no? You have a copy of the CCS pension rules? Check up the CCS pension rules, maintenance. You have a copy,
Lordship, I have a copy. No, your lordship.
Mary?
Yes, your lordship, here, it's a covered case, your lordship.
Mm.
All in all, the petitioner is praying for posthumous regularization. Direction for posthumous regularization has been set aside by the apex court in Nishibi's case. So, your lordship, it's a covered case, your lordship.
Yes.
Lordship.
Given the judgment.
Yes,
of
your lordship.
CCS pension rules 19.
72.
Paragraph 4, your lordship. Page 5.
Did your wife make any application?
No, your
No.
lordship.
Yes.
Lordship, in the Nishibi's matter, your lordship, 3 points were given, your lordship. Stating that, number 1, your lordship, that during his lifetime, the deceased employee have never claimed regularization, your lordship. However, in number 2, your lordship, they have given delay, your lordship, 12 years of delay, your lordship. Here, your lordship, the petitioner, after that his wife died on 2016, your lordship, on 2018, your
Do
lordship.
you maintain a seniority list?
Lordship, lordship.
When the wife was alive,
Lordship.
what was her seniority?
Lordship, that will have to seek instruction, but your lordship, here the prayer is for posthumous regularization.
No, that's fine. Posthumous
Lordship.
regular- But we have to be very clear before we dismiss the writ petition.
Lordship.
Just see what was her position in the, before she died.
Your lordship.
And then after that, we can dismiss the writ petition. It's a question of dismissal only, nothing much. So we'll give them some life for 1 week. You get, then we'll dismiss. Come prepared for dismissal. Mr. Hurt.
M. Solo, your
M. Solo, Learned Counsel for Petitioner. MS Mary, Learned Government Advocate shall obtain instructions with regard to the seniority of the petitioner's wife while she was serving as work church employee, correct?
Yes.
List after 1 week.
2 weeks, Your Lordship.
For hearing, item number 20.
Mr. Lordship. Your Lordship, I'm appearing on behalf of my senior who is respondent number 1, 2, and 3.
Mm.
Lordship, I better let this matter be passed over.
Why? Yes.
Lordship, my senior has personal difficulty to attend the court today.
Who's your senior?
I am the launcher. Yes, Lordship.
So you want an adjournment?
Let this case be listed tomorrow.
Tomorrow will be difficult. This is for what?
Your Lordship, it's about a discharging of it.
Yes, Yamawati.
I have no objection, Mr. Indy Loncha is on the physical history, so I have no objection.
On request made on behalf of Mr. M.T. Longchan and counsel for the petition.
Lordship, I pray that my name be listed in this cause list.
Hmm?
Oh, I pray that my
In the
name
cost
be.
list?
Yes.
Have you sent a Bagla number?
On your Lordship.
Then how can we list it?
Okay, I'll find the Bagla.
That's any.
On request made on behalf of Mr. M.T. Longchan and the counsel for the petition. When do you want? List the
Tomorrow.
matter after 1 week.
Okay, Lordship.
For hearing, item number 22.
Yes, Lordship.
Yes.
Lordship, the petitioner herein is the mother of the government business employee.
Mm.
And she's aggrieved by 9 settlement of family pension.
Family pension.
Yes, Lordship. Lordship, before I refer to documents, short facts, Lordship. The petitioner's son was appointed in the year 1995 as officer grade 2 on casual basis. Appointment was made against clear vacancy and scalping, Lordship. While working as a Lordship in the year 2003, her son was expired, Lordship. And after the death of my son, Lordship, in 2003, the service was regularized for the purpose of pension. Now, after regularization of the service of the petitioner's son, Lordship, pension papers were forwarded to the Accountant General. On several occasions, reminder was also sent by the directorate through the director to the AG. However, despite lapse of time, Lordship, family pension was not settled. Therefore, in the year 2019, the petitioner submitted a representation to the Accountant General for settlement of the family pension. However, Lordship, no positive response from the AG. Therefore, the petitioner filed the present writ petition. After filing the writ petition, Lordship, the AG filed the affidavit in opposition. By filing the affidavit in opposition, Lordship, the stand of the AG is that there is no records pertaining to the pension papers of the petitioner's son. Therefore, a letter was sent to the directorate to furnish the necessary documents. That is the stand of the AG. Now, they still respond, and respondent 1, 2, and 3 also filed affidavit in opposition. Lordship, including the director, Lordship. Now, dear stand is, Lordship, the regularization of the son of the petitioner was done by the director. There is no authority for regularization. Therefore, petitioner is not entitled for pension. That is the only stand of these two respondents. Rightly or wrongly, Lordship, my son's service was regularized in the year 2003 by the director. Now, my submission is, Lordship, director has the authority at that relevant point of time for appointment as well as regularization. because all the agreement was made by the director, and not only in case of the petitioner's son, Lordship, many other employees were regularized by the director, which is part of record. I have submitted the necessary documents which I obtained through the RDI. Therefore, in view of the documents which I've submitted before this court during the pendency of the writ petition, which was obtained through the RDI, this honorable court directed the state respondent to file additional affidavit to justify how the director have regularized the service of the petitioner and the other contract employees. Accordingly, the respondent have filed additional affidavit justifying to the action initiated by the director.
Which respondent filed the additional
Respondent number 1, 2, and 3, including the director, Lordship.
justifying?
However, there is no documents, there is no order, there is no guidelines to show that the director has no authority at that relevant point of time to regularize the service of the ad hoc contract and casual employees, Lordship.
Let us see that the additional affidavit.
Mr. Lordship, got it?
This dated 22nd May 2024.
Lordship. Responding close to an office memorandum, which is not relevant in this case, Lordship. And secondly, Lordship, they've also enclosed the rules of executive business.
1 minute.
Which we have it. Page 7 is the court's order, Lordship.
Page
Page 7 is the court's order, directing registered respondents to file additional affidavit, Lordship. Now, Lordship, page 8 is one office memorandum. By enclosing this office memorandum, Lordship, the respondents are trying to say that the director has no authority to regularize the service of
page 8,
page 8, Lordship,
26 August.
1998. This is with regard to appointment of ad hoc contract and temporary employees, Lordship.
You are appointed on as
As officer grade 2, as casual, Lordship,
casual role.
in the year 1995. This is notification of 1998.
Then
And next page is also, page 9 is another office memorandum. Memorandum of 2001. This also pertains to appointment, not regularization.
yes,
Which has no relevancy in the present case, Lordship. And page 11, Lordship knows it's an executive, roles of executive business, Lordship. Now, by relying the roll 10, which roll 10 of the roles, Lordship, now the respondents are relying on roll 10 clause 1 to show that the director has no authority and it is the government to regularize the service of the ad hoc contract and casual employees. However, nothing has been mentioned about regularization here in this roles, Lordship. Roll 10 clause 1. So Lordship, coming to the facts,
All parties are represented. AG is there.
yes, Lordship.
We are the standing council.
No, I'm appearing on behalf of my senior Joshua Shiki.
In fact, AG has no role in this case, Lordship.
No, but then are you the standing council?
No, Lordship.
Joshua Shiki is the standing council.
Yes,
Where is he?
He's around, Lordship.
He's around.
Yes.
Okay.
Lordship, I'll take your Lordship petition to page 19 of my raised petition.
Yes.
20 is the type copy, Lordship. This is the appointment order. Page 20.
Yes.
He was appointed against sanction post, against clear vacancy on his skill bill, Lordship. This order dated 17 May 1995.
Where is that clear vacancy?
Lordship, last second paragraph.
Okay.
Now, Lordship, while serving ourselves, Lordship, we kindly refer page 23. The petitioner son died on 24/2/2003, Lordship.
24 to 2003.
And next page, Lordship. Page 24. Page 25 is the type copy, Lordship. Read, Lordship. Page 25.
Oh. Write down.
Died on 24/2/2003. And page 25 is the regularization order issued by the authority, Lordship.
So the regularization was done after his death?
Yes, Lordship, posthumous regularization. For the purpose of family pension, Lordship.
Yes.
And next page 26 is the succession certificate issued in favor of the petitioner, Lordship. And Lordship, may kindly come to page 20. 29, Lordship, sorry. This letter was written by the director in the month of January 2005. Forwarding of pension waivers in respect of late M. Namaran or to the Accountant General, Lordship. And next page is the receipt. Beyond book, Lordship.
Which serial number?
Serial number 1, column 1, 2, 3, 4, Lordship. 3/2005.
3/2/2005.
On the left hand side, Lordship.
AG.
Yes, Lordship. And page 32, Lordship.
Yes.
Page 32. Is the representation submitted by the petitioner for early settlement of the family pension.
Yes.
Page 33. This is the another letter submitted by director reminding the AG to settle the family pension in respect of the petitioner's son. This is dated 16/6/2016.
1 minute. 11.
Page 33, Lordship. Thereafter, in the year 2019, Lordship, in view of non-settlement of the pension, Lordship, despite lapse of time, the petitioner submitted a representation. This representation was submitted in the year 2019, Lordship.
Who is that letter saying that they don't have the pension papers?
By filing affidavit,
Okay, by
Lordship.
filing.
I'll refer to Lordship later on, Lordship.
Who is this letter of 11/7/2005? Page 33.
It is, Lordship. It appears that Lordship may find
No,
this.
Page 29 is a different one. This is January 2005.
Lordship, may kindly page 30, Lordship. Page 30, it is mentioned on the right hand side down below, Lordship. Last 11/7/2005. Last column, right hand side, down below. Is it, Lordship? It's not legible, Lordship.
No, this is 11/2/2005. See, the director wrote on January 2005.
Lordship.
That was in terms of the what you call this peon book or whatever you call it.
Lordship.
The AG received it on 3/2/2005.
Yes, Lordship.
Yes, Your Lordship.
Then how can you say that you don't have the pension papers?
So, Your Lordship, it's unfortunate that we have searched the entire office, but there is no report.
And what about this 11/7/2005? Another reminder seems to have been sent.
11/7/2005, Your Lordship,
Page 33.
of the writ petition, Your Lordship.
Yes.
Page 33, Your Lordship, is the 16/6/2016 letter. So, Your Lordship, after this, the second paragraph, yes. 11/7/2005. That we are not aware, Your Lordship.
How?
We could not find it because this has been after many years and officers also, they keep on changing, my lord. So as far as.
See,
my lord.
okay, 11/7/2005 doesn't. But in January 2000, which year? 2005.
My lord.
January 2005. Pension papers were forwarded to your office.
Your lordship.
Which you have received.
Yes, as per the record, yes, but
Where is
we
it?
could not find the.
How can you
papers.
how can you misplace such documents?
Your lordship may kindly have a look at the paragraph 6 of my affidavit. My lord will kindly appreciate this fact that at that particular point of time, during 2003 to 2005, there was a maximum number of cases of fraudulent pension cases. So, my lord, we beg a sincere apology before this honorable court that records could not be traced, and unfortunate that the.
Where's your affidavit?
Your lordship, respondent number 4, affidavit. Paragraph 6, my lord. May I read, my lord? It's a very short paragraph. That with regard to a statement made at paragraph 10 of the writ petition, the answering deponent begs to state that the department forwarded the representation from Srimati to Shimanla, mother of late
Imlamern ex SO2 on 16/6/2016 after the lapse of 11 years. Every possible efforts were made to trace the documents, but to no avail. As per Director Rural Development letter number so and so dated 16/6/2016, it is stated that no sanction has been made towards family pension. That is in the letter of the Director, Your Lordship. No sanction has been made towards family pension in respect of late W.M. Namern ex SO2. So far, which is confusing, it may be mentioned here that there was a huge number of fraudulent pension cases during the period 2003 to 2005. However, this office has requested Director Rural Development to furnish the copies of pension documents, white letter number so and so dated 6/7/2022. On receipt of the pension documents in complete shape, the case will be settled. So we're not averse to it, my lord, but as I've
Where
already
is this
submitted.
letter? 6/7/2022.
Your lordship, that unfortunately is not annexed with
How
this.
can you not annex it when you have mentioned it?
My lord, yes, your lordship. So my lord.
On the basis of your letter,
yes, your
only this
lordship.
court is going to take appropriate steps.
I'll produce it tomorrow, my lord.
You produce it
Tomorrow. I will produce it, my lord.
Monday. We'll take up on Monday.
My lord. Your lordship. My
But
lord is.
Mr. Wati Jamia, learned counsel for the petition. Mr. Joshua Shiki, learned, you're the standing counsel accountant general or just?
Yes, I'm one of the standing counsels, your lordship.
The standing counsel accountant general shall produce a copy of the letter dated 6/7/2022.
Yes, my lord.
Reflected in para 6 of the affidavit in opposition filed by the respondent number 4. List on
Tuesday, Lordship.
Monday's what date? You want it on Tuesday? 25th?
My lord will be here.
Maybe I've been there. Let us see, whoever is the court will be there. There's not an issue whether this
My lord.
court is sitting. or
No,
not.
I thought this matter is going to be kept per her.
No, 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 I'm not.
My lord.
Monday or Tuesday?
Tuesday, Lordship.
Tuesday,
25th.
25. Produce copy of this one.
My lord, your lordship. Bless you, lordship.
For hearing, item number 23.
20.
May I please, Your Lordship? Your Lordship, in the last occasion, I was directed to get the necessary instruction
What
as to
instructions?
what the state respondents, if any steps has been taken after the cabinet's decision.
Yes.
Your Lordship, I've been informed that apart from issuing the intimation letter to the petitioner, no steps have been taken. No orders, notifications were issued after the cabinet's decision, Your Lordship.
Where is that cabinet decision?
Page number 21 of the affidavit, page number 20 of the affidavit of opposition of the state respondents, my lord. In action 9, page number 20.
After this, what happened?
After the cabinet's decision, petitioner was intimated about the decision taken by the cabinet, but officially no orders were issued or no notifications were issued.
Then
That's it, Your Lordship. After that, no action has been taken.
twenty 22 cabinet decision, you're keeping it in your pocket, huh? Doing nothing. You retired in?
2011, my lord. It's now more than 13 years. It's about 13 years. My lord, my prayer is to give a direction to the respondents to process and release my pensionary benefit. And then since although the cabinet have taken a decision, no formal order has been issued except the intimation letter. And then in the light of the Rafiq Masih's case,
Give me that Rafiq Masih.
2015 for SSC 334. The petition is already a retired person. Para 18, my lord, page 345.
You're governed by
Yes, my lord.
18.2.
18.2. No recovery from the retired employee. And then I have been retired since 2011 now. my lord. And then after delaying the matter for process of my pension benefit for such a long time again, recovery will be injustice. And then it will be against the judgment of this.
Have you taken any steps against the officers who have delayed in
No, your lordship.
nothing? Then we'll dispose.
Yes, your lordship.
I don't know how you are running your state government. Heard Mr. N. Kumar, Learned Counsel for the petition. Also heard MSAI, Learned Government Advocate appearing for the respondents,
1, 2, 3.
1, 2, and 3. And Mr. Joshua Shiki, Learned Counsel, appearing on behalf of the respondent 4, Oblique Accountant General, Nagaland. Stop. Para. The petitioner, while serving as a functional manager in the Department of Industries and Commerce, Nagaland. Retired. Where is this order of retirement?
The order of retirement is at page number 31, my lord. Annex F.
31.
Page number 31, Annex F.
Was released on retirement with effect from 31/10/2009
2009.
on completion of 35 years of service by an office order dated 27 July 2011, issued by the Commissioner and Secretary to the Government of Nagaland, Industries and Commerce Department. Stop. Are you challenging this order?
But, my lord,
Are you challenging this order?
no, I'm not challenging order. I'm just praying for release
You've been
from
given
pensionary benefits,
retrospective retirement.
my lord. By this, I was released from service. And then after this,
No, 2000, you have been given retrospective retirement.
yes, I have not challenged this.
You're not challenging this. Okay. Stop. However, since the issue of the order dated 27th July 2011, the petitioner was not paid his pension and other pensioner benefits, and therefore, despite filing representations, several representations before the concerned authorities. Stop. Therefore, petitioner approached his court by way of filing WBC number 150 of 2019, which was disposed of by an order dated 17/2/2021, directing with the following directions, was the, on 17 November with the following directions. Page 33, 88. Stop. Comma. Now, full stop. Para. However, comma, despite the order dated 17/2/2021 passed by this court in WBC 150 of 2010, comma, as no steps were taken for release of the pension and pensioner benefits of the petitioner, the petitioner approached this court by filing contempt petition within brackets civil 14 of 2021. Stop. The said contempt petition was also disposed of by order dated 22/2/2022 with the following observations and directions. Stop. B to B. Page 37. Stop. Para. Despite the directions passed by this court in WBC number, what was it?
150 of 2019.
WBC number 150 of 2019, as well as in contempt case number
14 of 2021.
14 of
2021.
14 of 2021. The process for payment of pension and pensioner benefits to the petitioner has not been completed, and the petitioner has been left high and dry since his retirement by the order dated 27 July 2011. Petitioner is before this court by way of the present petition. Stop. Para. The respondents 1, 2, and 3 has filed affidavit in opposition. Stop. In the said affidavit in opposition, it is stated that after the retirement of the petitioner by the order dated 27 however, the department received a letter dated 13/8/2015 from the senior accounts officer, Office of the Accountant General, A&E, Nagaland, Kohima, wherein certain clarifications regarding the excess pay and allowances drawn by the petitioner was being sought. Stop. The department, therefore, forwarded the matter to the finance department, which was further placed before the Personnel and Administrative Reforms Department for further examination. Stop. A 3-member inquiry committee was also constituted which gave its finding on 18/6/2019. Where is that finding?
It's number 12.
Don't say that. A 3-member committee was also constituted to look into the excess pay and allowances drawn by the petition. Stop. The 3-member committee made this recommendation on 18/6/2019, and the relevant portion is quoted here and below. Stop. Is C to C, page 13 of the affidavit in opposition. Stop. The recommendation of the inquiry committee was placed before the PNER department, and the PNER department, by its note dated 5/3/2022,
2020.
or 2020, agreed to condone and regularize the period of overstay by the petitioner, subject to the approval of the cabinet. Stop. It is further stated in the affidavit in opposition that the cabinet said on 23/2/2022. However, the cabinet did not approve the proposals for condonation and regularization of overstay periods in the state, in the service. Stop. The respondents, the respondents have annexed the minutes of the cabinet meeting held on 23rd March 2022. And this as annexure 9 to the affidavit in opposition, and the relevant portion reads as under D to D, page 20 of the affidavit in opposition. Stop. The further case of the respondents is that the decision of the cabinet was communicated to the petitioner, correct?
Yes, sir.
By a communication dated 26 July 2022. No. By the additional director of industries and commerce. Stop. When the matter was taken up on 14/6/2024, this court required a learned government advocate to take instructions as to what steps were taken by the respondents after the cabinet decision on 23/3/2022. Stop. Today, when the matter is taken up, learned government advocate submits that apart from the intimation to the intimation to the petitioner by the communication dated 26 July 2022, written by the additional director of industries and commerce with regard to the cabinet decision dated 23/3/2022, no other steps has been taken till today. Stop. The case of the respondents is that the petitioner had overstayed in his service, and therefore the excess amount drawn by the petitioner, excess amount by way of salary drawn by the petitioner, should be reimbursed by him. Stop. However, till date, no any order has been issued with regard to the reimbursement of the excess salary drawn by the petitioner. Stop. It is already a settled position of law that once an employee has retired from service, no recovery can be made with regard to excess salary being drawn. Stop. This ratio, the Honorable Supreme Court, in the case of State of Punjab and others versus Rafiq Masih, within bracket whitewasher and others, reported in 2015 for SCC 334 has held us under para 18 court authority. Stop. Para. This will be what is it? E to E. Stop. Para. The petitioner may have overstayed in service. However, the said overstay cannot be purely blamed on the petitioner alone, inasmuch as the concerned authorities had also not taken any steps to release the petitioner on his due date of retirement. Stop. Continue. Further, in terms of the cabinet decision dated 23rd March 2022, it appears that no steps has been taken against any hearing officers concerned on account of the delay in releasing the officials of supervision. Stop. Another important fact is that the petitioner was made to retire from service by the order dated 27/7/2011. Stop. Since then, petitioner is left with no other means of survival, and as much as no pension and other pensioner benefits has been paid to the petitioner. Stop. This is not permissible in terms of the settled position of law, as already reflected here in above. Stop. Para. Accordingly, this petition is disposed of, directing all the concerned respondents to forthwith take steps for processing the pension, pension papers in respect of the petitioners, and thereafter pay the pensioner benefits and pension to the petitioner in accordance with law within a period of at the earliest, but not later than 3 months from the date of receipt of a copy of the order of discovery. With the opposite of regulations and directions.
Direction maybe should not recover the excess payment.
So it is also made clear that in terms of the ratio laid down in the case of Rafiq Masih within bracket Supra, no recovery shall be made against any excess draw from the petition, from the petitioner. That must be from the
Lordship. For admission, item number 16.
In this case, the petition is challenging the suspension order.
suspension order. Counter has not come.
No, Lordship, but in this case, Lordship, the petition was suspended in the suspension order is at page number 23. This was issued on 16 June 2022.
23.
Page number 23. Now almost 2 years.
2022.
16 June. Well, more than 2 years. If the respondent already have not reviewed this suspension order, and as well as the petition was suspended on the alleged count of involvement in the criminal case. In the criminal case, no charge sheet has been filed.
No charge sheet.
No charge sheet has been submitted. This is a similar law which has been laid down by the apex court in the case of Ajay Chaudhary. If the suspension order cannot remain valid for more than 3 months.
Are you aware of Ajay Chaudhary?
Yes.
Then, have you reviewed this suspension order?
No, Lordship.
Are you sure?
I'm very sure. I've confirmed it.
You are challenging the suspension order? You are challenging only the suspension order.
After the suspension, after I'm suspended, just no development.
Ajay Chaudhary.
Lordship, become the para 12.
12. Para?
12.
So 21 has been violated. No charge sheet, no review.
Your Lordship, if we go by the suspension was issued by invoking the provision of section 6, clause 1 of Nagaland Discipline Appeal, Nagaland Services Discipline Appeal Rules 1967. Your Lordship, if we see the proviso to section 2, it also says if the delinquent is released on due, the authority can revoke the suspension. No, petitioner is on due.
Where's the
Lordship.
discipline and appeal rules?
Lordship, we come to the proviso to the sub rule 2.
Rule 6.
Rule 6, proviso to sub rule 2.
Sub rule
2 proviso.
Sub rule 1. Proviso to sub rule 2.
Mary, provided that where the detention is made on account of any charge not connected with his possession of a government as a government servant, or continuous in office is not likely to embarrass the government or the government servant in the discharge of his duty, or the discharge does not involve moral probity, the appointing authority may vacate the suspension order made on or deemed to have been made when he is released on bail or is not otherwise in custody or imprisonment. Now the petitioner is on bail.
He's on bail.
Is on bail. If the by order dated page number 19, also. By order dated 18/8/2022, he was released on bail. Page 19. Also.
Yes.
Lordship, I'll leave it to your wisdom.
That's the problem, like leaving everything to the wisdom of the court. Sometimes this court also finds it difficult. But then, can I record your statement that you have not reviewed the order?
Lordship? Yes, yes. There's no fresh order passed.
No review.
Yes.
Lordship, the petitioner was paid only a substance and a loss of 50% of his salary from the date of his suspension. Lordship, the area salary is directed after only statement.
Okay, heard Mr. Limaupang and counsel for the petition, as well as Mr. K. Angami. Leonard, you're the senior,
Lordship.
then the senior government advocate, appearing on behalf of all the respondents. Stop. While the petitioner was serving as a forest guard in the Mokchung range of Mokchung division, in the office of the forest guard in the Mokchung range of Mokchung division, he was placed under suspension by an order dated 16th of June 2022, issued by the Principal Chief Conservator of Forests and Head of Forest Force, Nagaland, in connection with MKG PS1 case number 0010/2022 under section 22 within bracket small b NTBS Act. Stop. The said suspension order was passed invoking the powers under sub rule 1, under sub rule within bracket 1 of rule 6 of the Nagaland Services within bracket discipline and appeal rules 1967. Stop. Para. The case of the petitioner before this court is that the petitioner was released on bail by an order dated 18/8/2022 passed by the learned special judge NTPS Mokchong Nagar. Stop. The further case of the petitioner is that the suspension order dated 16 June 2022 has not been reviewed till date. Stop. Has not been reviewed till date and no charge sheet has been filed against the petitioner in the connected criminal case, which is pending before the learned special judge. NTPS Mokchong. Stop. The learned counsel for the petitioner therefore submits that as no charge sheet has been filed against the petitioner in the connected criminal case, and as the suspension order dated 16th of June 2022 has not been reviewed till date despite a lapse of 2 years. On these two grounds, the suspension order of the petitioner is liable to be set aside. Stop. It is also submitted that the petitioner has been paid only 50% of the subsistence allowance till date, isn't it? Till date. Stop. Para. No counter affidavit has been filed by the state respondents. Stop. However, Mr. K. Angami, London Government Advocate, on instructions submits that the suspension order dated 16 June 2022 has not been reviewed at any point of time till date. Stop. Para. It is already a settled position of law that if no charge sheet has been filed in the connected criminal case, the suspension order is not reviewed within a period of 3 months from the date of issuance of such suspension order, the suspension order automatically the suspension order stands vitiated and is liable to be set aside and quashed. Stop. Para. In the case of Ajay Kumar Chowdhury versus the Union of India and another, reported in 2015, 7 SEC 291. The Honorable Court has held us under. You quote para 12. This will be 8A.
Para 21.
Yes. And further, at para 21, in the case of Ajay Kumar Chowdhury Supra, the Honorable Court has also held this under. B to B. I'm flicking it for you. Stop. Para. Recording the submission made by the learned government advocate that the petitioner, that the suspension order dated 16 January 2022, by which the petitioner was suspended, has not been reviewed till date. And also taking into consideration that no charge sheet has been filed in the connected criminal case till date, comma. This court is of the considered opinion that it was imperative on the part of the concerned concerned authorities to have reviewed the order dated 16 June 2022 within a period of 3 months from the date of issuance, and within a period of 3 months. This has not been done. And therefore, comma, applying the ratio laid down in the case of Ajay Kumar Chowdhury Supra, the impugned order dated 16 June 2022, issued by the Principal Chief Conservator of Forest and Head of Forest Force, by which this petitioner was suspended, is set aside in quash. Stop. Para. The respondents are directed to forthwith reinstate the petitioner. Stop. The petitioner shall be entitled to full salary with effect from the date of his suspension, minus the subsistence allowance already paid to the petitioner. Stop. With
Your Worship, as far as the money matter is concerned, if it can be effective from his reinstatement, allowance, as far as salary, Lordship.
no, that but it's already, we have not reviewed it with the other observations and directions with petitioners disposed.
I'd like
For hearing from the supplementary cost list, item number 27.
May it please your Lordship. I will be allowed to narrate the short facts to the leading of the filing of the application for making a reference to the court, which was filed before the Deputy Commissioner Kohima. Now, we have a common plot of land at Lerukutu, which is below National Highway 29, near below the present Assam Rifle Camp on way to Dimapur, about 6-7 kilometers from here. Now, sometime in that plot of land belonged to our grandfather, who had 4 sons, and I'm the son of the youngest son of our grandfather, and the rest have died. I'm the eldest surviving member of our grandfather. Now, that has never been divided amongst the children of our grandfather. Then sometime in 2020, we have been informed that somebody is working in our land. So sometime in May 2020, we went to check. Then we found some people working there. Then on inquiry, we were informed that that was purchased. That was purchased by one Rovilia from the one of the sons of our grandfather, called Tulhu. In short, he is called Tulhu. And we informed the workers there that this land belongs to our grandfather. This is our common property. So until the matter is settled amicably, you please stop working. Then after they have not stopped working. So finally, we were compelled to approach the Gamburas in 2021. We by filing a complaint. Now the Gamburas directed us to take oath and been aggrieved by that one, by the direction of the Gamburas before the dealership. When the matter was placed before the Gamburas, now the Rovilier brought a piece of paper on which is written that she has purchased from late Tulu, because Tulu borrowed money from her and having failed to repay, she was given the land. So it is in handwritten, a short note was produced before the GBs. Being aggrieved by the decision, we filed an appeal before the district and session judge, Kohima. And that was admitted, and the order of the deputy commissioner, order of the Gamburas have been suspended. Now, in the meantime, we were also, we also heard that somebody has taken compensation for land over that area, relating to plot number 57, 58, and 59. Now, after filing of the case and the appeal, this came to our knowledge, and we don't know who has taken. So we filed RTI before the deputy commissioner, and then we were furnished with the papers that the sister son-in-law, the son-in-law of Rovilier has taken the compensation. Then we received that information in 2022, sometime in June 2022. Then thereafter, in 2023, we filed an application because the land does not belong to the son-in-law of Rovilier, nor the land belongs to Rovilier. And the compensation has been paid to the wrong person. Therefore, we filed an application for making the reference to the court. Our reference application is annexed to this petition as Annex 2. Now, on filing of this application was received by the Deputy Commissioner on 18/4/2023. And on receipt of this application for reference, the Deputy Commissioner passed an order on 12 September 2023, which is Annex 1, page 16. May I read, Lordship? Yes. Whereas Sri Tejindule Sohail has submitted an application under section 12(1)A of the Nagaland Requisition and Acquisition Act 1965 for making a reference to the court. Whereas the applicant has submitted that he is the ancestral owner of a plot of land locally called Ler Tuku, located below the Assam Rifles Camp bypass, below NH 29, Kohima, parts of which is a matter of acquisition for 2 land Kohima bypass road, falling under JNH 002 10+500 and covered by plots number 57, 58, and 59, hereinafter referred as the plots. Whereas the applicant has submitted that he was not notified as per section 9 of the Nagaland Requisition and Acquisition Act 1965, hereafter referred to as the Act, whereas it is hereby clarified that after notification for acquisition for claims and for claims and objection within a period of 30 days by notification number so dated 1st February 2021 and circular issued for payment of compensation to the bona fide landowners by number so dated 12 January 2021 as annexed in Annexure 1 and 2 of the application. There were no claims and objections from any quarter, and so there were no necessity for invoking Section 9 of the Act. It is pertinent to mention that the Deputy Commissioner is not in the know-how of all the landowners traversed by the bypass road. Whereas as per Annexure 5 of the application, the ownership of the plots is under dispute and presently under litigation. That since the matter is sub judice, there is no necessity to refer to court under Section 12(1)(a) of the Act. Whereas the application is dismissed as deemed to be infractious, as ownership of the plot is sub judice, with the direction that the applicant may approach the appropriate forum once the matter of ownership of the plots is settled. So this was order was passed. Now we filed the application under Section 12(1)(a) of the Nagaland Acquisition and Requisition Act of 1965. And in our application, we have narrated how the land compensation was given to the wrong person, who is not the landowner. Now he has gone into the merits of the case, merits of my application, saying that there is no question to invoke the provisions of Section 9 of the Act. That is for urgent acquisition of land. In case of urgent acquisition of land, the proceeding under Section 9 can be taken. Lordship, let me take your Lordship to Section 9. This is Nagaland Code Volume 2. Page 26. Section 9 is at page 26. Very Lordship. Speedy acquisition of land in certain case, notwithstanding anything contained herein of before, if in the opinion of the state government or the collector, it is necessary or expedient to acquire speedy any land for public works, including any of the objects mentioned in subsection 1 of section 3 of the state government or the collector by order in writing, acquire the land, stating the area and boundaries thereof. 2. The collector shall cause the order passed under subsection 1 to be served in such manner as may be prescribed on the owner of the land, and also to the tenant or the occupant in cases where it is not in occupation of the land. And also a notice to the same effect stating that claims to be due compensations for all interested in the land may be made to him within such time as may be prescribed, provided that when the person to be so served is not readily traceable or the ownership of the land is in dispute, the collector shall cause the above order and notice to be published in such manner as may be prescribed. Now, for this purpose, 1 and 2 is most relevant. For speedy acquisition, this is the provision. Now, notice is to be issued to the owner of the land, specify the area and the boundaries of the land. Now, however, the Deputy Commissioner says that since at the time of payment, making the payment of the compensation, there was no objection, there was no claims and objections there is no question of referring to section 9. Now, Your Lordship, we are not challenging section 9. By information, by way of information, we are intimating to the collector that these things has happened. The land has been acquired without following due process of law, and also the land compensation has been paid to the wrong person. Therefore, make a reference to the court. That was our case. Now, when we are not challenging this Rule 9 before the collector or before any court, what is the purpose of referring this section 9 by the deputy commissioner, by the collector, and defend himself, his sections, saying that the deputy commissioner is not in the know-how of all the landowners? This action is tainted. This is tainted for collateral purposes. This has been included in this order. Now, Your Lordship, the other thing is, as reflected in this order as well, the land compensation to the wrong person was made on 15 January 2021. The circular is at page 26 of the petition. 12 January 2021. Annex 4. My Read, Lordship. This is to inform the concerned landowners that land compensation for Kohima Bypass 2 land project JNS so and so first package shall be paid in the office of the Deputy Commissioner Kohima on 15 January 2021 at 10 a.m. The concerned landowner is requested to be present physically and to bring along 4 recent passport size photos not to scan and other card, Xerox, ID proof, and bank passbook, front page Xerox. Payment to any other representative other than the concerned person shall not be entertained. Maintaining social distance, because this is during COVID.
This, you were not aware of this circular?
Your Lordship.
You were not aware of this circular?
Until through RTI, we were not aware. We were not aware. So only through RTI, we were furnished with these orders, as well as the person who has received the compensation. All these were given by the from the office of the Deputy Commissioner. Now in this, copy to, not to any individual, not to any individual landowner. The chairman in 7, copy to 7, the chairman Kohima Village Council for information and to inform the concerned landowners for necessary action. That is 1. Now, compensation was paid on 12 January 2021. Surprisingly, Your Lordship, at page 25, Annex 3, this is circular notification that the 1st January 2021, 1st February 2021. It is hereby notified for the general information that land from Chenage plus so and so full stretch of the land to land Kohima bypass project is required for acquisition for construction of 2 lands starting from Zotsama bypass junction, Zotsama to Kigwema village under Kohima district. Now therefore, in exercise of the power conferred by section 9(2) of the Nagaland Acquisition Act 1965, Acquisition Act of 1884, I, Sri so Deputy Commissioner, Kohima District, Nagaland, duly authorized by the state government as competent authority to hereby notify that if any person, party have any claim objection over the said area. The same may be submitted to this office within a period of 30 days with effect from the date of this notification. Then copy 2 in serial number 6, all concerned village councils for information. Now, this alleged notification was issued under section 9(2) of the Acquisition Act. This is totally contrary to what the section says. No area is mentioned, no boundaries is given. The notification has not given the name of the owners of the land or who is in occupation, whether there is any tenant, nothing. And then the village council is not the owner of the land. And by placing these papers, we apprise the collector, the deputy commissioner, that because of these things, compensation has been paid to the wrong person. And then subsequently, in view of the subsequent amendment of the act, solatium also is entitled by the landowner. And those things should be considered by the court. Now, the deputy commissioner, has a statutory duty to refer the matter to the court when an application is filed. Now, under section 12, we have filed under section 12 of the act. Section 12 says, reference to court. 1, the collector shall, in every case, A, where any person aggrieved by an award made under subsection 2 of section 11, made an application requiring the matter to be referred to court. The relevant part is for us, it's A. And B, then finally, refer the matter to the decision of the court. So the deputy commissioner cannot, while referring the matter, examine my application on merit. How the land has been acquired, what has been done, under what circumstances this was done. He has no authority at all to look into it. His statutory duty is only to refer the matter to the court by highlighting whether the compensation has been paid to the wrong person or not. Then the court will examine it. And if there is a case pending, and a case is pending, then the reference court will take care of that one. It is not the duty and responsibility of the deputy commissioner to dismiss or reject application under those grounds. Therefore, why the deputy commissioner is so interested to go into the section 9, and that there was no claims or objection when the money was paid? That no person has been notified, when no landowners have been notified. There is something here fishy. And why he is, by this order, why he is attempting to cover up the 2 notifications, payment of land compensation and the notification, which was subsequently issued after payment of the money.
Your case is that after the circular was issued by the deputy commissioner under section 9.
Yes.
For acquisition of land.
Yes.
It was not, anyway, that is not the issue here.
That is not the issue here.
Not the issue.
Yes.
Only thing is, your claim is that since you are the owner.
Yes.
And the compensation has been given to a different person.
Yes.
You made a reference before the deputy commissioner under section 12.
Your lordship, yes.
Now, deputy commissioner should not have gone into a reference application.
Yes.
But should have referred it to the concerned court.
Yes.
Without getting into the merits.
Your lordship.
And
that is, yes.
That order should be set aside and direction be given to the deputy commissioner.
Your lordship.
To proceed in accordance with section 12 as provided under the act. That's
Your
all.
lordship, that's all, your lordship. This is as short as that, your lordship.
Lordship, The respondents are not against the petitioner filing an application under section 12 before the deputy commissioner, but before he filed his application, the ownership of the land, the titleship. it was
Let
still
the
in dispute.
let the reference court decide it. It's not your duty. You've already paid the compensation.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
Now, parties who are aggrieved by being compensated to the wrong person, I think, and clause B, A.
A.
And A may make a reference before the
Yes.
deputy commissioner. Deputy commissioner's duty is to refer to the court. But you should not have entered into the merits and then dismiss his reference application. That's all.
But Your Lordship,
This
without
court
a
is
rightful
also-
owner, no reference can be made. That's why the deputy commissioner,
No,
dismissed
that
the
the,
application.
but the concerned court will take the decision. And this court is also not entering into the
Yes, Your
merits.
Lordship.
Because this court cannot enter into marriage, all this court is going to say is that the petitioner alleges that he is the owner of the so, and in terms of the circular, compensation was paid.
Yes,
However, claim of the petitioner is the compensation is paid to a wrong person. And therefore, being aggrieved, he made a reference because it will be one page
Yes,
order
Yes.
that he made a reference under section 12. However, instead of deputy commissioner referring it to the court, dispose of on merits, which is not permissible under section 12. And therefore, that order is set aside and then the direction is given to deputy commissioner to proceed in accordance with section. Yes.
Yes.
Can we finish it?
Yes. Up to your lordship, that one is
I think the short order will do.
short order will do. Yes.
Third, Mr. R. Iralu, learned senior counsel, assisted by Mr. L. Iralu, learned counsel to the petition, as well as MSAI, learned government advocate, appearing on behalf of
Respondent 1 and 2.
all the respondents, correct?
Yes.
Stop. The present writ petition, is it writ petition?
Yes.
The present writ petition has been filed challenging the order dated 12 September 2023 issued by the Deputy Commissioner Kohima Nagaland on the ground that the Deputy Commissioner Kohima Nagaland has exceeded the jurisdiction provided under section 12 of the Nagaland
Requisition and Acquisition Act.
of the Nagaland Land within bracket requisition and acquisition close bracket Act 1964. Stop. Para. The case in brief is that the Deputy Commissioner Kohima issued a notification on 1st of February 2021 for the general information that land from chainage 0 plus 000 to chainage 43 plus 450 is required for acquisition for construction of two lane starting from Jotsuma bypass junction within bracket Jotsuma to Kikuima village under Kohima district. Stop. The said notification was issued invoking the powers conferred under section 9 within bracket 2 of the Act of 1965. on top where I said land acquisition, so, no? Within bracket, you say Act of 1965 in short. Stop. Draft. The another circular was issued on 12 January 2021. Huh?
Yes.
No.
First compensation was paid. Then subsequently notification was issued.
How?
That's why I'm saying that there is something fishy here, and these things were,
Cancel that order.
the deputy commissioner is trying to
The case in
hush up something.
is that by a circular dated 12 January 2021, issued by the Deputy Commissioner, Kohima, Nagaland, it was informed that the concerned landowners were informed that land compensation for Kohima bypass 2-lane project dash chainage 0 plus triple zero to 10 plus 500, not 000, within bracket first package shall be paid in the office of Deputy Commissioner Kohima on 15th of January 2021. Stop. The said circular was also endorsed to the chairman Jotsma Village Council and also the chairman of the Kohima Village Council. Stop. By another notification dated 1st February 2021, the Deputy Commissioner Kohima notified for general information that the land from chainage 0 plus triple zero to chainage 43 plus 450 is required for acquisition for construction of 2 lanes starting from Jotsoma bypass junction within bracket Jotsoma to Kikuma village under Kohima district. The said notification was also endorsed to all the concerned village councils amongst others. Stop. It is the case of the petitioner that the petitioner was not aware of the circular dated 12th January 2021, as well as the notification dated 1st February 2021. And therefore, he could not make any claim against his landed property in the said acquired areas. Stop. The further case of the petitioner is that the land compensation as provided under the Act of 1965 was paid to a wrong person.
Yes.
Stop. Therefore, being aggrieved, the petitioner invoke section 12A. Section 12A of the Act of 1965 by making a reference application before the Deputy Commissioner, isn't it? Where's your reference application?
Page 17, Annex 2. Received on
Invoking the provisions of section 12 within bracket 1 within bracket A of the Act of 1965 made a reference application before the Deputy Commissioner oblique Collector, Kohima District, Nagaland. Stop. The grievance of the petitioner before this court is that while considering the reference application made by the petitioner, The petitioner has, the Deputy Commissioner, Kohima, has entered into the merits of the case. Yes. And thereafter dismiss the reference application as being infractious by the order dated 12 September 2023. Stop. Para. MSAIME, the government submits appearing on behalf of all the state on behalf of all the respondents submits that as the ownership of the land under in dispute is sub judice before the appropriate court, the London Deputy Commissioner, Kohima, has accordingly passed the order dated 12 September 2023, and therefore no interference is called for. Stop. Para. I've heard the learned counsel for the parties, and on consideration of the materials available on the court, as well as a perusal of Section 12 of the Act of 1965, it is seen that the Deputy Commissioner, Kohima, while passing the order dated 12 September 2023, proceeded to enter into the merits of the case and came to the conclusion that as the ownership of the plots is under dispute and presently under litigation, there is no necessity to refer to the court under Section 12 within bracket 1 within bracket A of the Act of 1965. Stop. This, in the considered opinion of this court, was a wrong interpretation made by the learned Deputy Commissioner while passing the order dated 12 September 2023. Stop. Section 12 of the Act of 1965 provides that the collector, in every case falling under Section 12 within bracket 1 within bracket A and within Section 12 within bracket 1 within bracket B, when a reference is made, the duty of the Deputy Commissioner of the District Collector is to refer the matter for the decision of the court. In that view of the matter, this court is of the considered opinion that the Deputy Commissioner should not have entered into the merits and should have referred the matter to the court. Stop. Accordingly, the order dated 12 September 2023 is set aside and the matter is remanded back to the Deputy Commissioner Kohima to strictly act in terms of provisions of Section 12 of the Act of 1960. Stop. That much will do.
Your Worship.
With the above petition is disposed.
What's your pleasure?
Ai là. Chưa? Hả? Không có. Thôi.